Whenever. Good morning, everyone. Welcome to this special commemoration of the 35th anniversary of a landmark Supreme Court decision in the history of education law and the history of Latino civil rights, and certainly in the history of MALDEF. My name is Thomas Saenz, and I am the President and General Counsel of MALDEF, the Mexican American Legal Defense and Educational Fund, and we view Plyler versus Doe as one of our most important historical decisions in the life of an organization that is now 49 years old and will be celebrating its 50th anniversary next year. We're pleased to be here at the University of Houston Law Center in the center of Texas to commemorate this decision, which emanated from this very state based upon a state law that sought to deprive undocumented children of the right to a free public education. That went to the Supreme Court, leading to the Plyler versus Doe decision on June 15th, 1982. It seems appropriate to be here commemorating this 35th anniversary in 2017 as a living commemoration, because unfortunately we have threats across the country, including from a new administration that pursues immigration policies designed to create fear and confusion in the immigrant community, including those undocumented children who were plaintiffs in Plyler versus Doe. It also seems appropriate to be here in Texas, a day after the district court in San Antonio heard argument against SB 4, this state's law that would seek to permit every police officer to make his or her own decision about whether and how to enforce immigration law, without much regard for what the impact of that might be on the very students who were plaintiffs in Plyler versus Doe. So we are here in this living commemoration with some of the folks who were directly involved in Plyler. I want to thank the University of Houston Law Center for hosting us today and welcome all of you who are with us by live stream and present in the room. Those present in the room, you'll see in the middle of your tables some index cards and pens. That's for you to write down your questions that will be collected by Gina Montoya, my colleague, to present to the panelists toward the end of our program. But before we introduce our panelists, it's my great pleasure to welcome the 9th Dean of the University of Houston Law Center, a legal scholar renowned for his work in issues varying from corporations to race, justice, and the law, the 9th Dean of the University of Houston Law Center, Leonard Baines. Welcome, Dean Baines.
Thank you so much. Good morning.
Good morning.
Good morning. It's really great to be here, and I'm very proud of the University of Houston for its efforts in this regard, and really proud of hosting MALDEF in this. MALDEF is one of the premier civil rights organizations in the country, and so it's really great for us to be here. On this really very challenging times, as Tom has mentioned, we're in a very, very difficult moment. But I want what universities and law schools can do is they can be places for conversations and discussions such as this that help bring light to sort of issues that affect us. And so I'm very proud of us being able to do that. And what we also do is we have a leading legal scholar in immigration and education law, Michael Levis, who is here, and he's the perfect embodiment of this conference because he specializes in education law and immigration law and Latino civil rights. Let's give him a round of applause. And we also have our really renowned immigration law clinic that has won awards from the American Immigration Lawyers Association, and its director has won awards from American Immigration Law Association. Plus, he's also won the Ethel Baker Award for Community Activism at the Law Center. Jeff Hoffman. And his team, Rosemary Vega, Josephine Sagwe, and Janet Beck. I don't know if I've seen Janet. Is Janet here? She's not here, okay. But what we can do as an institution is we can make sure that we're a place for the conversations to take place, but also a place for those who may have issues can seek refuge from our premier immigration law clinic. As Tom was saying, there have been really a lot of challenges in the past few months, and our immigration law clinic has stepped up. There are a lot of students and others in our community that have issues given the changing laws and regulations. And Jeff and his team have been on the barnstorming across the campus and across the state, trying to make sure that people know what their rights are. And so those are things that we can do as an institution to make sure that we move in a positive direction. And I also think it's really important for us to recognize that the world may change, but really the arc of justice moves in a positive direction. So these may be, short-term reverses that we may see, but we have to be optimistic that the future is going to be in a positive direction. Immigrants have been the lifeblood of our institution and our society. My parents were immigrants, from a small island in the Caribbean called St. Vincent and the Grenadines. But for the U.S., I wouldn't be here today before you, a Columbia-educated lawyer, dean of this great law school, because the U.S. opened its doors to us and had opportunities for so many of us. And so I think it's really important for us to keep that in mind. And that is really the trajectory. There may be reverses from time to time that we may see, and we certainly have done that with respect to civil rights and immigration. But overall, the U.S. has been a place that has been accepting of all people of all different backgrounds. So I welcome this conversation today. I apologize that I won't actually be here, as I've been on the road myself. I was in New York, and I'll be in Washington, D.C. this weekend, and I go to Mexico City later in July. So I apologize because it's a great conversation, and I will miss it, but I'm sure that Michael and Jeff and Josephine and Rosemary will keep me apprised of what went on. Thank you so much.
Thank you again, Dean Baines, for welcoming us here and for making the University of Houston Law Center available to us through the great auspices of our friend Michael Olivas. I'll introduce Michael and the other panelists briefly in a few moments, but first we want to premiere a short video produced on Plyler versus Doe. We produced this video at MALDEF in recognition of the continuing importance of awareness of the decision so that as we progress further in 2017 and through the challenges that we face, folks will understand the very basic, important decisions made in Plyler. So with that and with no further introduction, let me introduce the short video from MALDEF on Plyler.
You want us to dim the lights? Samuel?
Children who are illegal aliens cannot
be denied a free public education.
A 5-4 vote, the court said a law which required them to pay tuition was unconstitutional.
The Supreme Court's ruling in Plyler versus Doe, in which it rejected a Texas attempt to charge tuition to undocumented students in kindergarten through 12th grade public school, was a landmark decision for civil rights of Latinos and immigrants in the United States. The case basically established two critical propositions. First, it rejected the state of Texas convention that undocumented immigrants were not persons for purposes of the U.S. Constitution, and instead concluded and made clear that persons includes everyone, including undocumented immigrants, such that they could call upon the protections of the Equal Protection Clause of the 14th Amendment. And second, the court established a right, enduring today, that every student has to access a public school education free of charge, regardless of immigration status. Plyler versus Doe means that every child gets to go to school and complete school without undue obstruction because of immigration issues. That means that even immigration enforcement that occurs in the transit corridors where kids walk to school, where kids take a bus to school, can violate Plyler. It also means that intimidation of parents, keeping them from being involved in the schooling of their children, keeping them from volunteering, may also be a Plyler violation. It also means that the things that might not involve actually being on a campus, but a field trip or an extracurricular activity, have to be made available to undocumented students as well. anything that prevents or deters a child from getting a full education, kindergarten through 12th grade, can be a Plyler violation.
These were innocent kids. They were not responsible for being in this country. And there's a whole body of law that talks about, and the court adopted, that talks about not punishing children for the sins of their parents.
Every night, hundreds of Mexicans enter Texas illegally, often bringing with them children who often end up in the Texas public schools.
While the court split 5-4 on whether the Constitution prohibited what the state of Texas was trying to do, all 9 justices joined an opinion, majority or dissenting, that recognized that it was senseless to choose to deny a basic education to any child, including an undocumented child.
Texas was very much a segregated society. One of the things that I recall as a child is the refusal by a cafe to serve Congressman Henry B. Gonzalez.
And this was East Texas. We talked about Texas being a bad place. East Texas is the sort of place that, I spent a lot of time in Tyler because of US v. Texas and Plyler. But, it was the first time in my life that I saw black people walking down the street and they wouldn't look me in the eye. That's the sort of place that Tyler was.
So Plyler versus Doe came out of an attempt by the state of Texas to allow school districts to charge tuition based on the immigration status of enrolled students. Of course, the Supreme Court knew, as did everyone, that charging tuition effectively meant that those students would be barred from attending public school. Faced with a bill, they would simply not be able to attend public school. And that's what the Supreme Court addressed, concluding that it made no sense to deprive any child of a basic education as would be acquired in kindergarten through 12th grade public school.
Whether undocumented immigrants were covered by the Equal Protection Clause, there had never been a flat-out holding on this. There had been a holding on due process, but not on equal protection. This was a sure winner for us. We had limited amount of time to argue that we would let that one sit. We had plenty of other things to argue about rather than whether undocumented people were covered by the Equal Protection Clause. And we had briefed this all too. We clearly briefed it. Soon after I stood up, Thurgood Marshall boomed out in a sort of inimitable style of, sort of blasting out.
I haven't heard the 14th Amendment or whether or not this is a person yet. And this is about 5 minutes from the end of the argument.
Pretty clearly, Thurgood Marshall didn't need to know, but somebody else did need to know. Common misunderstanding that what Texas did was directly exclude undocumented kids. They effectively excluded undocumented kids by basically saying we're not going to reimburse school districts for their education.
The state of Texas tried to argue that there was an excessive number of undocumented school children. They provided data that they had no basis for providing. There were just guess estimates, and they were talking about in the hundreds of thousands, 100,000, I can't remember the exact number. And this has a multiplier effect when you look at the cost per pupil in terms of supporting them annually for schools.
This was a case that I thought had to be filed because it affected children, innocent children who didn't make a decision to be, quote, illegal aliens, close quote. They followed their parents, which is what any child would do. So it was the combination of the unfairness of it all, visiting this kind of result. And that was from the sort of empathy, moral point of view. But the other point of view that we thought about is, look, for all practical purposes, these children are ours. They belong to the United States.
Talk about slippery slopes. I think if we had lost this case, there were plenty of states waiting in the wings to enact similar legislation. So, you're scared to death that if Texas is allowed to exclude undocumented kids, who's next up? And you're empty-handed if the court has ruled. And we've even seen, even having one Plyler, we've had to deal with that in California, of all places, We've had to deal with it in Alabama. There have been various firefights that we've had to put out in terms of undocumented access to schooling.
As you know, cases are decided in a contextual environment. And the contextual environment was not sympathetic to, quote, illegal aliens, close quote. And the legal issues that you heard expounded by Tom Sines and Peter Roos were there. Is the Equal Protection Clause, which has been elusive even for citizens, is it going to apply to this vulnerable group? And fortunately, the Supreme Court said it did.
I can remember screaming. I can remember my wife giving me hell for screaming so loud, wake all the neighbors. I said, if you knew why I was screaming, you'd be screaming too. And I sort of walked on air down to the bus, which I took into MALDEF, and it was a day of dealing with the media and also pondering how close it was and what could have happened. I remember sitting around at lunch, just being unbelieving that we were one vote away from having lost this.
I hope that as we move forward, that this case, this landmark case, will provide a basis for making the clear arguments for supporting immigrants and their families, stopping family separations, and unfortunately, as we see in the current time, the current administration is going the opposite direction and working with people who essentially don't want foreigners in this country and are using every excuse to minimize not just illegal migration, but also legal immigration.
Plyler is a constitutional decision, and what that means is that no one, including the President of the United States, can decide to override Plyler. That constitutional right to attend public school free of charge, free of obstruction, from kindergarten through 12th grade, means that every child and his or her parents have the absolute right to enroll and attend public school. Any threat to that right, whether in the form of a clerk who says you have to produce a social security number to enroll, or an ICE agent who decides to patrol outside of a public school campus or enter a public school campus to begin questioning folks about immigration status, is a violation of Plyler. It should be reported to the school authorities and to civil rights organizations like MALDEF around the country, because the Constitution protects against that kind of obstruction of public school access for any child and any child's parents.
As a country, we say that we are proud of our immigrant heritage. We don't always practice that. I happen to believe firmly that it is our greatest strength. At times, it's attacked. I think it's a bit under attack now, and I think we all need to fight back. When it's about you, maybe you won't speak up. But when it's about your child, you will stand up. That's what it was.
Many of those undocumented students have become lawful permanent residents and even U.S. citizens, making contributions in academies, in corporations, and in our workforce throughout the country. So Plyler has really made it possible for our nation to thrive accessing the talents of all students, including undocumented immigrant students. So thank you, and I want to be sure and thank Sandra Hernandez and Antonio Marcano of MALDEF's communications team for working on putting together that powerful video that we felt was so necessary given the challenges that we face today. It's now my great pleasure to introduce our esteemed panelists and invite them up to the front to have a discussion about how Plyler developed and how the area of law has developed over the course of 35 years since then. It's my great pleasure to begin by introducing Michael Olivas, who is the Bates Distinguished Chair in Law here at the University of Houston. Michael is a longtime member of the MALDEF Board of Directors. He is an esteemed legal scholar, probably the most renowned scholar in the area of immigrants in education. He has authored or co-authored over 15 books, including the quintessential treatment of Plyler versus Doe, No Undocumented Child Left Behind. He just finished a stint as interim president of the University of Houston downtown, and I have to add, because I know he would want me to, that not only is he a scholar in education and immigration issues, but a scholar of rock and roll law, probably the most well-known scholar of rock and roll law in the country. Welcome, Michael Olivas.
Thank you.
It is also my pleasure to introduce a lifelong education civil rights lawyer who has argued two of the most important education rights cases before the U.S. Supreme Court, Plyler versus Doe being one of them, Goss versus Lopez being the other. Someone who has been involved throughout the country in ensuring that every child has access to an equal education, and who continues to do that work even today in his quote-unquote retirement. The lead counsel in Plyler versus Doe, Peter Roos. Welcome, Peter. And certainly, last but not least, my predecessor, the president and general counsel of MALDEF from 1973 to 1982, during the time that MALDEF was pursuing Plyler from its filing in 1977 through its resolution at the Supreme Court in 1982, a leader in civil rights who also served on the University of California Board of Regents, currently serves as the chair of the Board of Harbor Commissioners in Los Angeles, and recently finished 4 years as the first woman ambassador from the United States to Argentina, my predecessor, Vilma Martinez. Welcome.
Thank you.
This is an esteemed panel with so much expertise in this area, I almost don't know where to start. But I'm going to start with the fact that looking back 35 years, it's often easy to fall into the myth of inevitability, that somehow it was inevitable that Plyler versus Doe would come out the way it was. That's ordinarily not the way it's actually experienced at the time. So let me start with you, Peter. You argued this case before the Supreme Court in early December of 1981 and had to wait, as too often happens, to the end of the Supreme Court term in June, not knowing when the decision would come out. Talk a little bit about how you felt after the oral argument, and as those 6+ months went by waiting for a decision, were you expecting it to come out as it did, or what were you thinking?
You know, you never know how these things are going to come out. The press, of course, makes projections, and I think the projections on a 5-4 ruling were, as one would expect, were all over the map. You know, so we waited. We didn't sit still. As I mentioned in the video, I spent a lot of time in Tyler, Texas. After U.S. v. Texas, after Plyler, I then spent 2 months in Tyler, Texas, before the same judge who tried Plyler, trying the statewide bilingual case, U.S. versus Texas. So grass didn't grow under our feet while we were waiting. I think I was also involved in a Denver DSEG case as well. You know, you just don't know. You're scared to death, as I indicated there. I mean, if you lose, almost different people motivate themselves in different ways. But one of my motivators is the terrible fear of losing these cases, and the necessity of presenting the best case I possibly can, just because I don't want to be responsible for the loss. I mean, obviously, there's the desire to win is tremendously strong, but so, you know, those 6 months or so were you know, when I thought about it, were fearful times as well.
Vilma, how about you? What were you expecting? You took a chance on taking this case and pursuing it all the way to the Supreme Court, and you're waiting over 6 months as well for the decision. Were you hopeful? Were you frightened about what might occur? What were you thinking?
I was busy working on a lot of other issues, making sure that MALDEF was viable, continued to be viable. But the story that I'll tell the audience is this. I started my career out of Columbia Law School at the NAACP Legal Defense Fund. Jack Greenberg was then the head of that organization, director counsel. And one of the things that I learned from him was that sometimes you have to take a risk, where even though you think the likelihood is that you will lose, nonetheless the issue is so important you need to proceed. And that's pretty much how I felt about this case. MALDEF at that point in time had a litigation review process so that before filing any lawsuit, we analyzed the facts and the law that applied to the facts, the likelihood of success or not, at what point we thought the matter would be resolved, could it be negotiated or would it have to go all the way to the Supreme Court, and if it were, we thought, to go to the Supreme Court, how much would it cost? So we had that analysis, and Peter prepared that analysis. And I remember, Peter, you may not remember this, but as the person who had to meet the budget, I remember discussing this with you and going over it very carefully and thinking, well, you know, the likelihood of success. I couldn't say that I thought we were going to win, but I could say that we had to file. And so we did file, and then, of course, came the fun part of raising the money to make sure that we could afford every step in the proceeding. So that's my memory of it. And I'm not the sort of person like Peter to just sit around and wait for something. I mean, we knew what the process was, and it would just evolve. And in the meantime, we had a lot of other cases to file, a lot of fundraisers to go to and raise money for the organization. So that's pretty much how we approached it. But we did all feel that it was such an important case because, as I said in the video, it involved innocent children, but I also made the point that it involved education. You know, without education, what will happen to these children? And we thought these kids were ours.
Just to add on to what Vilma said, the process that we went through, the law had actually been passed over a year before, and we sort of waited for what we considered the opportune time to file the lawsuit. And so the process we went through was quite a ways before we actually filed it. And it turned out that I got a call from a guy by the name of Larry Daves, who was a civil rights attorney and probably the only civil rights attorney in East Texas at the time, and in Tyler, just before the Labor Day weekend in whatever year it was, 1977, I guess, saying that the Tyler schools, and this is interesting, the Tyler schools, like many other districts, really did not. There was bad stuff in Texas. There's no question, bad stuff all over the country. But there were school people who really did not want to exclude these kids from school. And Tyler had actually kept them in school for a few years. And finally the numbers, if you know Tyler, there's the Rose Gardens out there and people come to, that's basically where the undocumented population sort of works. I guess had grown, and so the schools had there was a financial crunch as well as an increase of undocumented kids, and so at any event, just before Labor Day, they decided that they were going to exclude undocumented kids, and so I did talk to Vilma. I said the time has come, and got on a plane and spent Labor Day weekend preparing for the case, and was in court on that following Tuesday, I guess. So once we got going, we moved.
Yeah. So, Tom, one other point that I don't remember at what point I did this, but as you know, I was on the Board of Regents at the University of California, and a colleague of mine on that board was the superintendent of public instruction for the state of California, Wilson Riles. And I don't know whether, Peter, we had just filed or the case decided. My guess is filed. I don't think it had been decided, but I asked Wilson Riles, I said, Wilson, what are you going to do about these children in California? And his response was, well, if they come to school, I'm going to educate them.
And I think that probably would have been a typical response of educators from that perspective. But as Peter mentioned, Michael, this began in 1975 with a Texas statute that said the state would no longer pay for undocumented students to go to school. What brought that legislation about?
Well, this is one of those kinds of things where no one wants to claim the infamy. It came without debate, like so many other. Not that we do that, today at all. But it ended up as law. But they didn't change the truancy law. So these kids were actually still required under state law that was of long standing and universal. They had to be in school till 16, and so it flew in the face of that. These kids being held out of school would have violated law, putting these parents in a terrible predicament. And remember, at the time there were several hundred school districts, and many hundreds, and some some charged as much as $1,000. Remember, 1976. Even today, that would be tuition in some schools. And so it was really quite onerous. And of course, these parents were not very sophisticated. They didn't know MALDEF at all until after the fact. And the kids, of course, are quite regularly referred to, and in the case itself, as innocents. One of the interesting things, even talking about this, was this has the effect of demonizing parents, frankly. Because in the arithmetic of it, if there's innocence, then there's got to be some transgressor, the parents who brought them here, which played out with DAPA in the last year or so, 2 years, when President Obama tried to give some relief to them. And the interesting thing is that despite a number of challenges that are regular and routine, this has largely been upheld and frankly venerated in many respects. It certainly is a high water mark of civil rights and immigrant rights. And things broke right from MALDEF in a variety of ways. It could have gone south at so many areas. And I think the preparedness, the courage, the fact that it was a wildcatting crapshoot, because you put all your money out and then you only win it. You only get money back if you win, and that doesn't always happen. So I thought that it was courageous. It was strategic. Vilma and Peter bet the entire organization on this in many respects. And I remember being a law student at Georgetown when Vilma came. I played hooky one night, went to a fundraiser that you held there, and it was lining up political support. The new administration was coming in and so forth, and everything simply went right for us on this case. It probably didn't seem so at the time, and it could have been squirreled away, especially when it was combined with another case here in Houston. I came to the University of Houston in August of 1982, so I've lived Plyler here my entire 35 years in Houston, and I will tell you that it was a major legal victory and a major moral victory for this population.
Peter, let me ask you, Peter, about the filing. As you indicated, it was September 1977. So Michael's mentioned it being consolidated with another case here in Houston, but talk about why Tyler and how you found the folks who stepped forward to be the plaintiffs in representing the class.
There were a number of sort of strategic considerations. There was a judge who many of you know and some of us venerate, William Wayne Justice, who sat on the bench in Tyler. They used to say that there was two judges in Tyler. I don't know who the other one was, but they'd say you got justice or no justice. We got justice. So that played a role. The fact that the numbers were not so large out there, we knew we had a statewide case and a nationwide case, but And let me go back to the judge. I mean, yes, it's good to have a good judge and to expect that you may well win with him. But the other thing is having a good judge meant that he would listen to all of our testimony. We've all, especially in those days, but I think it happens today, you can run into judges who just don't want to hear you out, especially if they don't like your politics. And Judge Justice heard everybody out, heard the state out as well as us, but we wanted the opportunity to present a record. Slight transition to what Michael said about the blaming the parents. The reason there was the innocent children argument, which was a major argument, which was true, of course, had to do with legal authority as well as a certain amount of sentiment. The legal authority, which went back to a number of Supreme Court cases dealing with illegitimacy, which said you can't blame a parent for the acts of their parents. And there were several other cases like that. There was a case, I think, of a child in the Fifth Circuit case of a kid who was kicked out of school in New Orleans because his parent came in and raised holy hell, and they said you can't do that. That said, and I think it's important for the record, that we presented the parents, and these parents, like the overwhelming number of parents of undocumented kids, were people who were law-abiding, people who had never taken any public aid at all, who paid taxes. If they weren't paying property taxes, they were paying them indirectly. They were paying them indirectly through rental. Most of them actually paid income tax, and they weren't collecting refunds. So these were like most of the parents of the kids that we're talking about were people who were, other than the fact that they were seeking a better lives for their families and themselves by crossing the border, were not lawbreakers. They were good people who were trying to crawl up, trying to make a decent life for themselves.
And Peter, talk for a moment about recruiting those parents and getting them to put their names, even though by pseudonym,
sure,
on a lawsuit that they didn't know the outcome, just like you didn't know the outcome.
Sure. There's several aspects of that. I mean, we actually had a liaison, a guy by the name of McAndrews, who worked at the Catholic school. Some of them had been accommodated at the local Catholic school, but as Michael said, it's expensive to educate. The Catholic school was willing to accommodate a couple of them, but ultimately it became too expensive for them. So we sat down over that weekend and met with the parents. And one of the things that I'm sure there are people in this room who are representing undocumented people regularly that we felt that we had to do was to tell them that, yes, we will try to file this case without using their names under pseudonyms. But there is a distinct possibility that somebody could find out who you were. You just always have to say that. I mean, there's no guarantee that sticking your neck out isn't going to result in somebody finding out and your neck being chopped off. And there was actually a poignant moment at the preliminary injunction trial where the judge himself said, I'm not going to I'm going to have the testimony live, and I'm not going to do it behind closed doors. I just don't think I can do that. It's only in sort of national security cases that's authorized. And so we went down. The parents were actually below the courthouse, down in sort of, believe it or not, I think there are holding cells down there for prisoners who would be brought up to trials. And we went down and said, this is what the judges said, and the United States, and he also refuses to hold the United States to any sort of a limitation on what they do with the information that comes out in this trial. Although the United States, frankly, the attorney said that we don't intend to do anything with it. We said, that's what they said, but this is an issue. And without a one, they marched up and said, it's worth our while.
So, of course, the danger was of a different sort, but Vilma, I want you to talk about, it's easy to assume in 2017 when there's more or less a consensus, at least on the progressive side of the political spectrum, that we need immigration reform, that undocumented immigrants' rights have to be protected. But in the 1970s, even on the progressive side of the political spectrum, the undocumented population didn't have that level of support. So MALDEF took some risk in taking on this case as well.
Well, MALDEF took a huge risk, and it was not easy to persuade our board to add what we called immigration, domestic civil rights crossover issues. When I went to MALDEF as predecessor to Tom, and that would have been in 1973, and what we found, and Peter, you came soon after that, what we found was an organization that reacted to the so many very different problems of the day. And the board and the staff ultimately decided to focus on areas where we believed we could make a difference, and there were three: education, employment, and the Voting Rights Act. And that was going on about the same time as we were dealing with Plyler, because the 1965 Voting Rights Act was up for extension. It did not cover Mexican Americans, so we were arguing for expansion of the Voting Rights Act. So I was reading about then Attorney General Saxby going to Cameron and Hidalgo counties here in Texas to talk about these illegal aliens, in quotes, taking away American jobs.
Wetbacks. Wetbacks was the term.
Yes, there was that.
No, it was a very common term.
There was that.
Yeah.
So that was the sentiment, and I kept hearing more and more of it, and I didn't have any background in analyzing this. So I actually had to study a bit and read some works by authors such as Wayne Cornelius and Michael Piori, which talked about the scapegoating of undocumented aliens and our history of scapegoating them, so that in the 1930s, during the Depression, we had the repatriation of these folks. In 1954, during a recession, there was Operation Wetback, ferret out the illegals and ship them back to Mexico, always Mexico, so we could create more job opportunities for American citizens. So that was the environment in the early 70s. And we were looking at other issues, such as our own population is comprised of citizens, permanent resident aliens, undocumented aliens, some of whom are documentable, others of whom are not. But when the INS, there was no ICE then, it was INS, did a raid, they didn't make these fine distinctions. We all kind of looked the same. So we saw issues there. We saw issues in employment. There were cases coming to us where there was a citizenship requirement for jobs, and it wasn't a job-related requirement. So we were wondering, should we take that case in employment? And so long story short, we, the staff, felt that there was a lot of activity in what we called immigration, domestic civil rights crossover issues, and went to the board asking the board to let us take on this fourth major program area and let us fundraise for it. Not everybody agreed. It was a very difficult discussion. I don't know if you were there for part of that, Peter.
Sure I was, yeah.
You were. So it was not, we weren't at all certain that our board would agree. But ultimately, our board did. And so this is why, another reason why we were able, when Plyler v. Doe facts came along, we were able to say this is yet one more example of the immigration, domestic civil rights crossover issues, because our families are mixed, as we now speak of it today. So that was the time.
Michael, you've looked at this case. Talk a bit about the lack of consensus even on the progressive side of the spectrum in the 1970s around these issues. I mean, it's easy to look back and say, oh, that was an easy case to take on, but in fact, it was cutting edge.
It was is the way I characterized it. It took enormous courage because the organization truly would have been hollowed out if we had lost this case, in my view. We had already won register a voting rights case, a Supreme Court case, barely. And in Texas, that's just the front end. The implementation is still always the issue. We had really sort of lost Denver, even though we changed the decision there. And we didn't have the respect, the national stature that we have today. Today, now that it's been done, it seems inevitable, but it wasn't at the time. We sort of bet the ranch on it, it seems to me. And not only with regard to the internal governance, but because we weren't always so focused and because this was new, it was unknown territory, really. There are a lot of organizations. Now, MALDEF is the go-to organization. If there's a immigration case, they come to us. If there's an education case, they come to school finance. Those are our areas. Very few national organizations have the reach and the technical expertise and the deep commitment to carry all of these agendas forward. There's only a handful, and it's very difficult because many of the others were either originally membership organizations like the ACLU, which is able to take on hundreds of these cases. But MALDEF was still finding its way, and in my view, this made MALDEF the premier organization for these kinds of events.
So, Vilma, in the course of this case, beginning in 1977, but then extending to 1982, you go through a transition from the Carter administration to, at the time, what was viewed as an unprecedentedly conservative administration in Ronald Reagan and his election in 1980. Talk a bit about that transition. It has obvious relevance to today, and how you thought about it in terms of the cases that MALDEF was taking on, including Plyler at the time.
Well, you know, I had a personal life as well, shocking as that may sound. So that in 1980, I had just had my second son, Ricardo, and I was getting ready to leave MALDEF, thinking, oh, you know, I've done what I could, and it's time for younger people with more energy to take over. And then Reagan gets elected, and the staff goes into this funk. And I'm thinking, no, this is not what MALDEF is about. MALDEF is about doing its job. So while Carter was there, we were able, to some extent, to leverage governmental resources to help us with the civil rights agenda. With Reagan in office, it was the opposite. We had to sue them to get some rights confirmed and enforced. And so I decided, no, I have to stay at least until I have the staff going forward in the way, because to me, the reason that I applied for this job in 1973 was that I felt it was extremely important for us to have viable institutions to support the interests of this particular minority group that I belonged to. And so I knew that there would be good times and that there would be tough times. And as I have read and believed, that when the going gets tough, the tough get going. And that's pretty much what we did in 1980. So we had to change our strategies from leveraging to suing.
So, Peter, I'm sure you weren't one of the ones who went into a funk with Reagan's election, but you were involved in all kinds of important education litigation, including Plyler, of course. Right. And you've got this dramatic changeover in the federal government. How did you react to that? Did you have concerns about Plyler? How did that, at the time, very difficult transition?
Well, I mean, a big issue was we had gotten support from the Carter administration. In fact, we were talking last night that Leonel Castillo from Houston had been the head of INS, and he actually had been on the board of MALDEF. And so I had spoken to him about, in fact, when Judge Justice said that he felt that he could, his hands were somewhat tied in terms of the clients. I went to Leonel and said, you know, what sort of policy can we expect from you? And Leonel was, you know, very good and firm, and this is under the Carter administration, saying, you know, you can bet your bottom dollar that we're not going after anybody. That isn't to suggest that sitting in East Texas that the press couldn't have jammed things up and created the sort of hysteria that we see today. So that was a situation at the time we tried the case, and I think at the Fifth Circuit. But the Reagan administration was in effect when we argued at the Supreme Court, and there was huge debates about what the Solicitor General was going to do, what the administration was going to do, and ultimately they took a neutral position. And that didn't happen just by happenstance. It happened because Vilma and I and a whole slew of other people around the country, and trying to enlist some of our more conservative friends as well, said this is the right thing to do. And that is a lesson. You want to go to some of your friends who are rational, but who get the ear of some of the people who you otherwise might not have the ear to argue your case. And the result was that we did get sort of neutrality, which was as good as we felt we could get, and it worked out fine.
Interestingly, buried as a footnote is 2 Department of Justice lawyers who wrote memos against this, John Roberts and Samuel Alito, both on the record as thinking this was the wrong decision and they should oppose it.
So, Michael, from your perspective, talk a bit about comparing this transition that we're still going through.
Right.
We're less than 6 months in, or about 6 months into this new administration, with what was also considered a transition that overturned political expectations with Ronald Reagan.
Well, you know, the thing that Peter mentioned was the role of the press in East Texas. What has, in my view, fundamentally changed is the social media world, where this is litigated and articulated and discombobulated and lied about openly and very broadly in a way that it's much harder today, it seems to me. I don't try these cases, but just observing, it's become very, very difficult. And sometimes that works to your advantage because you have a defendant who tweets and that becomes part of the record. I mean, how extraordinary is that? I think the real images here today, I hope that, or the real trail marks here today, I hope that it works out as well for us and for the polity as happened there, because I will tell you, it wasn't always clear to me that we could win this case, and I was afraid that if we lost, it would set us back forever. The calculation that was clearly articulated here, and we, you know, 5-4 is very tenuous, and the court is aligned the same kind of way today with a swing vote. Remember, we had lost Rodriguez with essentially the same court in Texas not long before, and we had no reason to believe a case in which we were peripherally involved, that we weren't the lead plaintiffs. So it wasn't at all clear we could win this case. Once we did, it became, you know, God's grace that we won, and since that time we've been shoring it up and resisting all efforts to undo it, including more recent ones. But the truth is, we had the narrative on our side. This is something that people forget, is that law is about narrative. And there's no better narrative than we had. We had the facts on our side. Mark White, the Attorney General for the state, sort of conceded we had the facts on our side, but they had deep pockets. They could have outlasted us.
And they fought us hard.
Yes, and they didn't just hand it to us.
No.
We won this case.
So let's, since we're at the University of Houston Law Center, let's talk a bit about the legal issues here. Peter, in the video, you talked a bit about the preliminary issue. Were undocumented children persons for purposes of the Equal Protection Clause?
Right.
Talk a bit about how that developed.
Well, there was no law, as Tom also said in the video, that there was no law at the time that defined what a person was for the Equal Protection Clause. There was a case that described, it was a person for due process purposes, and there was another sort of technical equal protection due process argument that the Due Process Clause talks about. You are protected if you're within the jurisdiction of the country. The Equal Protection Clause doesn't use that term, and so the state tried to argue that that you couldn't be within the jurisdiction of the country, and that you couldn't be a person. Ultimately, the court sort of, didn't spend a lot of time. They pretty much said, there's no reason for distinguishing between the Due Process Clause and the Equal Protection Clause on this. And that was sort of our take, but we were certainly well prepared for dealing with it, as I indicated in the video. But it was not until Thurgood Marshall boomed out at me and said, Mr. Roos, I'm infuriated that nobody has addressed this issue, that we did. And so it clearly was not a throwaway. But one of the issues, and some of you will probably argue cases in the Supreme Court, you realize you have a limited period of time, although I think we were given extra time. I think I was sort of the cleanup hitter on the case, and I think I actually was up for over a half an hour on my own time alone, which wasn't typically allocated. But you do have to figure out what's going to make a difference, and what you think you can dismiss, put aside. And so that's how that issue came up, or those issues.
So, Vilma, some folks would react to the state of Texas contending that undocumented immigrants aren't persons within the jurisdiction and therefore can't call upon equal protection with shock. But you grew up in Texas. You know what Texas is like. You also experienced what we continue to experience at MALDEF, which is, as I say, it's always Texas. I think that Texas may be one of MALDEF's, through its 49 years, major donors through an involuntary provision of attorney's fees recoveries. So talk about your experience in Texas. Were you shocked that they were putting forward this argument that undocumented children couldn't even call upon the Equal Protection Clause?
No, in a word, no. I've always said that in many ways Texas is our Mississippi. And I was recalling, now this is not about my childhood, but it illustrates what my childhood was like. A colleague of ours, Drusilla Ramey, and I argued a different case at the Fifth Circuit called, I think it was called Morales versus Shannon. It was the Uvalde school desegregation case. And there were two anecdotes there. We had not tried the case, we just handled the appeal, but in looking at the record at the trial court, there was a petition filed by the German American Parents Association stating that these children weren't being discriminated against, but if they were, all they had to do was powder their faces white. So that was the other bit in the transcript was the plaintiff. She was not a model citizen, shall we say. She had, I think, a few illegitimate children, and the defense counsel were taking advantage of that. And she was very brave, and she said, well, I knew this would come up, but I'm here because I want something better for my children. She was a very strong woman. And the appeal was heard by a 3-judge panel, and I think it was Griffin Bell who was on that panel, who was looking at other parts of the record and said, well, how could these children be citizens? They don't speak English. And one other judge fortunately answered for us, and he said, they're born here. So this was Texas. I started school unable to speak English. I hadn't learned English at home because my grandmother spoke only Spanish, so basically we spoke Spanish at home. And in those days, there was no Head Start, there was no kindergarten. It was first grade and, good luck. And fortunately, I had a wonderful teacher named Miss Butler who kept those of us who didn't know any English back, and at her own expense and in her own time would go over the day's lesson again to try to get us to get it. And so we were always at the mercy of the teacher, and some were kinder than others, let me put it that way. And then in junior high, I was told that they were sending my record to the technical and vocational high school because I would feel more comfortable there. And I said that I had no desire to feel comfortable, that I wanted to go to the academic high school, Jefferson, so kindly forward my transcript there, which they did. So I go to Jefferson High School. I'm the treasurer for the National Honor Society, and I asked the counselor who oversees us how to apply to college because no one in my family had been to college, and she never made the time to talk to me about it. But I heard other kids talking about the University of Texas in Austin. So I wrote a letter to the University of Texas, Austin, Texas, put a stamp on it, how does one apply, and they sent me an application blank. So I filled it out, and I went there. Once I was there, I told them I wanted to go to law school, and they said, don't get your hopes up about law school. It's too hard. So I was taking a course from a common law professor, and as I said to him, I don't know what's going on here because, I am making good grades, and they're telling me not to get my hopes up about law school. So he said, don't be stupid, Vilma. They're discriminating against you. Apply to those liberal Eastern law schools. And I was washing dishes in the biochemistry lab, and I'm having this conversation with my boss, and he said, don't be stupid, they're discriminating against you. You should apply to those liberal Eastern law schools. And I said, well, what are the liberal Eastern law schools? And he said, I don't know, but go talk to someone in the government department. So I went to the government department and talked to Professor Mendelsohn. I said, Professor Mendelsohn, when people speak of the liberal Eastern law schools, what schools do they mean? And he rattled off a whole list, including your alma mater, but he told me not to apply there because it was too liberal. So I ended up at Columbia Law School. And when UT gave me their Distinguished Alumnus Award, I told that story. But those were very different times when they still had the drinking fountains for hombres aquí, and then we would go to the movies since that at the top we weren't welcome in the main floor. So that was my Texas.
Just a footnote for everyone who's interested in sort of learning a little bit more of this history. There was a U.S. Civil Rights Commission study about Chicanos or Mexican Americans in the schools in approximately 68, I believe. That is well worth looking at if you're interested in the history of Mexican American discrimination in the state of Texas. In fact, we borrowed liberally from it in putting together a set of stipulations with the state of Texas in U.S. versus Texas. But there were such things as punishment for speaking Spanish and the like. There was a range of, from segregation to punishment for speaking Spanish. But it's, sometimes some of these things get forgotten, and they shouldn't be forgotten because they, as Tom said earlier, sort of what the dean said, what goes around comes around. You hope it keeps moving a little bit forward, and I think it does, but what does go around does come around, and it's worthwhile knowing this history.
Absolutely. Peter, I don't know if you know this, but I served as an unpaid consultant to the U.S. Commission on Civil Rights for 5 years on that study. It was the education of Mexican Americans in the Southwest, and they issued 4 or 5 different reports, and all of those things are documented there. It's quite thorough, it's fascinating, and it's really very well written.
So beyond the equal protection question, Michael, the other issue, of course, in Plyler was about access to an education. Right. You mentioned already that the case started only 4 years after San Antonio Independent School District versus Rodriguez, where the court, another split Supreme Court decision, concluded that education is not a fundamental right. Yeah. That in the aftermath of Brown versus Board and the importance of education. So you indicated there was no inevitability about the idea that every child, including undocumented children, should be entitled to a K-12 education.
Right. One additional thing is in the book that I wrote many years later with the benefit of hindsight and the brilliance that comes to all quarterbacks who weren't there on the field at the time, I regretted that the decision didn't turn more on preemption. I actually think preemption was a winning topic. It would have caused its own problems, because then it would have made clearer that the feds could have done something about this. And remember that there's always a backdoor to Plyler, which is if this only restricts the state's ability to do something. Federal government reserves the right to do something. And I will tell you that I've never felt that we were closer to that than today. In all these years since that time, when a legislator in Oklahoma, as he did 2 weeks ago, says, hey, we got all these problems with these kids in the schools. We don't have enough school finance. Let's just turn over all these English language learners to ICE. Well, yeah, sure, that'll solve that problem. It's always had to be preserved. Like a lot of Supreme Court cases, the real fight is implementation. What happens when you win, and shoring it up and so forth. But Plyler has been, there's only been one serious federal attempt, the Gallagher Amendment, where the feds decided or actually took on the issue of federalizing education for purposes of immigration. It was shouted down because it was so absurd an idea at the time. And I don't worry about saying this in public, because it's not like these folks don't know this. You know, I'm not delivering the keys to the kingdom. This is hiding in plain sight. But there are a number of threats, and even today, Tom, there are issues that are situation specific. You mentioned the ICE agent who, without warrant in New York, tried to go after a fourth grader. The use of Social Security numbers as identification, even to pick up your children after school, or a driver's license, where these parents are ineligible for Social Security numbers, and in many states for driver's licenses, or the mixed citizenship families, where some kids are birthright citizens, others are not. So the older kids are at risk, the younger ones are not. I swear, every time a city declares itself a sanctuary, which has no real legal meaning to it, ICE has the equal and opposite reaction. They went in at New Haven and investigated people who were taking out library cards, because people said they would use that for identification for schools. In Santa Fe, New Mexico, they used these kids as bait and hung outside schools. And once they knew they couldn't go onto the school grounds, but once you dropped them off, the parents were fair game. So these families always have alternative fallback plans if grandpa is arrested and so forth. And it's winning is one thing, but it doesn't just stay there. It's not static. It has to be fought for, it has to be defended, it has to be reconceptualized, it has to be reapplied. And the narrative continues, and you don't just sort of set aside, move on to the next one. You have to do that, but shoring up wins is as difficult sometimes as actually gaining the wins.
So Vilma and Peter, you both were involved in Plyler, and then a dozen years later, you're both in California. And California, of all states, I said previously it was always Texas, but it was California in 1994 that passed a provision as part of Proposition 187 that would have directly barred undocumented students from going to public school from kindergarten through 12th grade. Indeed, the proponents made clear they were trying to set up a challenge to your victory in Plyler versus Doe. And although neither of you was at MALDEF at the time, you were both involved in challenging Proposition 187.
Yes.
So I want you each to talk about that a dozen years later, and you're having, as Michael said, to shore up the victory in your own state of California.
All three of us were involved in different litigation. Vilma and I were, you represented the Los Angeles
and
School
San
District,
Francisco.
or San Francisco,
Yeah,
and I represented groups of kids and organizations, I'm sure, and in a state court case, and Tom was involved in a federal court challenge, all of which prevailed, and all prevailed, at least in terms of the education piece, because of Plyler. They were articulated, the rulings were articulated in different ways, but clearly, as Tom indicated, the people, who supported it was a proposition, and those of you who are newer to the world than Vilma and I are, may have this notion of propositions as being this great democratic way for dealing with legislatures that are discriminatory, but the history of propositions, certainly in California, is to the contrary. Every bad thing you can think of somehow comes out of people signing petitions and getting things on the ballot and propositions. But yeah, Plyler did save us in that day, and it does go to show that Texas in 1976 is not alone. This was California in 1994, right? So this all can keep on happening and probably will.
Well, in 1994, I was in private practice with a firm called Munger, Tolles & Olson in Los Angeles. And as Tom said, many people in the education business wanted to educate these children. And so LA Unified, Matisa Quesada was the board member, and she knew about our work at MALDEF, my prior work at MALDEF, and so she called me and asked if I could represent, my firm could represent LAUSD, and then somehow, I can't remember how San Francisco also hired us. So the two huge districts of California, school districts, hired us, and Brad Phillips from Munger, Tolles and I got the first TRO against the education component of 187. MALDEF.
We did.
We did.
We did.
That's right.
Yeah,
we did.
yeah.
And you remember that.
Oh, yeah. It was a great morning.
It was a great win. But here's the thing about 187 that I found fascinating. Two things. One is that it didn't concern only education. So MALDEF had to deal with the well, in addition to the education, all the other components, healthcare, et cetera, components of Prop 187. But what struck me about that is that it galvanized the Latino community in a way I have never seen. Because I remember just parking my car, and I hate driving, so I paid for valet parking right at the office building, and the gentlemen who would park the cars were maybe undocumented, but they said to me, and they were always unfailingly polite to everyone, but they were furious, and they were saying, Ms. Martinez, I don't care how I'm treated, but I really care about how my children are treated. And I thought, yes, indeed. So it was a real turning point politically for this community in California. I mean, there's a reason California is now heavily Democratic. But as I warn my friends who are politicians, the key to opposition is success. You need to have a successful state. You need to have a community where everybody feels they belong, because if you don't have that, if you don't further that sense, you will absolutely create division. So I'm going off in a different tangent here, Tom. I'm sorry about that, but I truly believe that's going to be the key to success.
Absolutely. So, Michael, you've looked at these many attempts after Plyler to undermine it. Obviously, Proposition 187, the most significant. Only 12 years after the decision, a 5-4 decision. That's why the proponents of 187 thought it was vulnerable. Was it vulnerable? How important was it that 187 was defeated in court?
Well, it turns out once again, the grace of God happens here. I mean, it could have been someone other than Gray Davis who ends up settling the case. It could have been someone else other than Tom Sines litigating this case so brilliantly. It could have been, at that time, it was a red state. It had a Republican governor. It had Republican legislators. It had overwhelmingly populism result of the proposition itself. Things did not look good, but the darkest hour is always before the dawn. I mean, not only do I believe in the mamas and the papas and the Shirelles, but that actually happens to be the case in this history. It was not inevitable, but we lucked out. We had Plyler. I thought that the on-the-ground work to get editorials, and they overplayed their hand, and that's the link to today. Just like with Social Security and so forth, these guys think that they have all the power and they can use it wrongly and against the arc of history, and then they overplay their hand and they lose and they can't recover. Who would have thought that California would have been such a blue state as it is today? At the time, it seemed about as red as Texas, and with the same kind of demography and so forth. And today, it's complete opposite. I just hope that when the Democrats are in charge, they don't overplay their hand in being mean to the losers at the electorate. So I think that there are object lessons here. I haven't sorted them all out because Texas is certainly ripe for this with regard to demography. 60% of the school children in the state, not those coming over on the train from Honduras, kids here are Mexican American, Latino, most overwhelmingly Mexican. These are kids who are here. And I think what's happened is that the interests of the school districts converged. They saw that on head count and all other kinds of things, you need bodies, you need kids, and might as well educate these kids. It's not just always that they're educable or they're viewed as, our little inocentes who have to be mothered. It is that these kids are driving the enrollments. And by the way, no school districts have ever gone back and altered their funding formulas to accommodate Plyler. So now it's just head count and other kinds of things that we litigate. So it's when states like Virginia and even some other southern states now have rules to enshrine Plyler. One thing I do worry about is whether or not the Department of Justice will continue to issue in education their annual or regular guidance in this regard. That's something that has to be. This is sort of back to the Clohan and Republican turnover with regard to President Reagan. That's where we are right now. It's not at all clear to me that the current Education Department or Justice Department feel. I know they don't feel the same way. It's not at all clear to me they will back the play of MALDEF and the school districts and the states when they begin to take on these kinds of cases as are inevitably going to arise, because MALDEF is going to see to it that they arise.
Let me, Tom, just add something. We've all of us have talked about 5 to 4 equals 9 and how close the decision was, and it may be Pollyannish, but I tend to believe that if you were the vote that would be the fifth vote to deny millions of kids an education and put them on the street, you would think a lot harder than if you were the fourth vote to dissent. And people talk about John Roberts as being having dissented as a young lawyer. Actually, I think he was a White House counsel or something at the time, or in the White House General Counsel's office. Yes, the decision was close, and we all breathed a sigh of relief. And Hugh, and the court is not probably as good a court as it was as we had at the time. But we do have 35 years of experience, and I also do think that if you were a person, no matter what your politics were, and you realized that your vote could tip the difference in terms of putting several million kids on the street, even if you didn't care about the kids and you cared about what a million kids on the street are going to do to you, you might well think a little bit harder. So yes, it was close, and this is just reading tea leaves, but I do think that it's worth thinking about that.
Well, it's now a decision that's 35 years old. It's got a little more of stare decisis behind it for that reason. But I think it's also important, as Peter points out, to remember how the case came about. And it's important to remember that 3 of the 5 justices in the majority were appointed by Republican presidents. It's important to remember, as I often point out that even the dissenters, Chief Justice Berger in his dissent said it is senseless policy to deny an education to these kids. But it doesn't mean it hasn't been tried in the years since, including outside of California. So, Michael, the most recent threat in the form of state legislation was out of Alabama following SB 1070 in Arizona. Alabama enacted its own version. Talk about what HB 56 would have done had it.
Well, they overplayed their hand once again. They drew a statute that was so precise and so crazy that it would have excluded refugees and asylum seekers. Not that we would ever try and put restrictions on asylum seekers in this country, but Alabama overplayed their hand, and the 11th Circuit finally slapped them down, saying, "Look, this goes way too far." And so it's not like states won't do it. It's just that today it seems inevitable. I mean, MALDEF, of course, was involved in HICA and the case, so we had to rush in. But it didn't have the kind of sense that we were about to be overturned. I know I was on the MALDEF board at the time, and I felt we really were at risk, but it wasn't in the polity. It wasn't in the national narrative at the time. It was sort of an obscure case, except to those of us who followed it. And I always figured that the 11th Circuit would deal with it resolutely, and the Supreme Court wouldn't take it up. We can always be wrong on these kinds of things, but once again, this sense of states overplaying their hand, we were able to beat it back with excellent lawyering, a good set of facts. And I won't say here sympathetic judges. Arguing these kinds of cases in the South is very, very difficult. They don't have, here in Texas at least, they knew what Mexicans were, and and so forth in the Southwest. But more recently, so many of these cases are actually arising in the South, where Mexicans are once again characterized as crossing the border to wreak damage, stealing jobs for Americans. You haven't heard that kind of scapegoating language in the Southwest, in my view, as often as you do in the South. And the black-white binary there, where almost all the civil rights cases were African American against a white power structure, we're a little slower to adopt Mexicans and Latinos as part of the equation. So we were back to like Denver, where in Denver there were more Mexican kids than there were black kids in the school district, but the desegregation case was brought by blacks originally. We were interveners in that, sort of late to the game. That's the point. Even though that was in Denver, the first Western deseg case, that always struck me as a quintessentially Southern case because it was black and white, even though more kids were Mexican in Denver than in now. So part of it is demography. These things have shifted. Part of it is MALDEF has more national reach. We wouldn't have taken a Southern case in the deep South, it seems to me, at the time. Would you have? Would you have taken this case if it were more Southern than Texas, Bilma?
Well, it depends on the principle and whether it would have a big impact on wherever we were. And one of the things that I looked at when I was running MALDEF is when you look at the migrant stream and settled out migrants in places like Toledo, Ohio, and the Yakima Valley in Washington. So we had cases in all kinds of very unexpected places. So the answer probably is, depending on the issue, yes, we would have.
But it's certainly true the context has changed for a lot of these battles, although in a moment we're going to come back to Texas. But before we do, I think one thing important about Alabama's law was that it was not a direct prohibition of enrollment. It was an effort to deter enrollment and participation in school by collecting data on not just kids, but their parents' immigration status, so an indirect bar. But Peter, it's also true, and folks don't always remember this, that Plyler was an indirect bar. It was simply the state of Texas saying we're not going to pay school districts to educate these kids, and the school districts could react by kicking them out, or as Tyler did, by seeking to charge them tuition. How did it play out that way?
Well, I guess it was easier to to say we're not going to reimburse and you school districts can do it. You want it. It plays into local control concerns. How you can do what you want, but we're not going to give you any money, and then you full and well what the results were going to be. Yeah, I mean there have been a lot of sort of indirect things. You mentioned the Social Security. We've all dealt and still do with issues of asking kids and their parents for Social Security cards. There was actually in Plyler an argument made by the state saying that we are not discriminating on the basis of immigration or race. What we're discriminating against is that, and this goes back to within the jurisdiction stuff, we're just discriminating against people who don't live here, non-residents. And of course, hold on here a second. That doesn't sound right. But that was an argument of the state. I mean, obviously, when you stand up before a court, you throw out anything you think may stick on the wall. But there was that, and then of course there was a case a year or so later involving. I guess Brownsville, in which the court actually did hold that Brownsville and the state of Texas, through legislation, could exclude kids who are coming across the border. They could have genuine residence requirements, but this wasn't. They tried to convince the court that this was just a residence requirement. What's wrong with residence requirements? Talking about kids who'd virtually spend their entire lives in Texas and maybe in the Tyler school district and whatever school district they were in. That didn't fly. But residence requirements has been a sort of an alternative mode of trying to discriminate. I know there was a case a few years ago, I don't know if it actually became a case in Long Island, in which they tried to say that somehow more than one family could not live in an apartment, and so that if people came in, if from two different families into say the Massaquoi school district and showed that they lived in this apartment, they said, well, you guys are going to have to choose, and it was clearly just an effort to discriminate, because obviously poor people and primarily immigrants were in single apartments for financial reasons. So yeah, we're going to see a lot of that, and one of my great concerns, I think we were talking last night a little bit about this concern with the new administration of just sort of enabling discrimination, that we're going to see teachers and people who are not such good people saying, well, now I can get away with reporting kids to ICE and stuff, and that's going to cause some issues. But clearly there are legal tools for the Federal Educational Rights and Privacy Act and others that prohibit people from doing that, Fourth Amendment reasons, et cetera. There's a bunch of rights, but we're going to have to be very wary about these sorts of ancillary ways of excluding undocumented kids from school.
So in addition to the indirect ways that folks may try to keep kids out of school, there are even more indirect ways of tackling or targeting the constitutional principles that were established in Plyler. So I want to fast forward to today. And the opening remarks, I talked about Texas has recently enacted SB 4, which is an unprecedented anti-immigrant state law that basically allows every police officer, sheriff's deputy, booking agent, or other law enforcement official to decide on his or her own, one by one, whether and how to enforce immigration law. But Michael, one of the things, in fact, the only sensitive location, as identified by previous administrations in immigration enforcement, that is specifically excluded in SB 4 is kindergarten through 12th grade public schools. If there are police officers who are employed by school districts, they don't have the ability under SB 4 to make their own minds up about enforcing immigration law. So does that exclusion mean that Texas has learned the lesson of Plyler?
Would that were the case. The funny thing is it shows cycles, because these kids, Doe goes to college eventually, and so we have all these dreamers today, over 800,000 who got DACA at one point. And if you think that we made a lot of trouble over 6,000 Syrians and Afghans, try and unring the bell on 800,000 of these kids who made their way through, who are lawyers and doctors today and so forth. It's been an enormous progress. And Texas was the first state to sign into law twice, both for financial aid as well as in-state tuition. So I thought they'd sort of learn their lesson, because that was only 10 years after the Plyler case, in fact, almost exactly 10 years. And they still have very generous terms for college students here. At the same time, SB 4 no longer treats these areas as special. Colleges were always considered off limits as well, these kids going, even though Plyler doesn't affect them, the moral principles behind Plyler do, and the accommodationist view is very important and has advanced the interests. Because once these kids graduate from high school, as they do, often at the top of their classes, they've got to have a place to go, and even the loud silence that the current administration has had with regard to DACA, the interorum effect of these is what's really troubling to me. When I was president of the University of Houston downtown, I had over 500 dreamers. In fact, I brought Josephine, one of my former students, there to do a workshop for them, and I was never prouder that one of my students was there advising these kids on their legal interests. And I remember being so despondent, because these kids know that I helped write that law, and they always were very sweet to me about that. And when afterwards I was riding the elevator back up, and this guy gets on, he says, "Presidente Olivas, llegamos tan cerca." We came so close. And I just burst into tears, because these kids were looking to me for leadership, and I didn't know what to tell them. I was so despondent, and it was like everything I had spent my whole life in favor of had been rejected because of not getting out the vote in 3 damn states. I mean, come on. And so, but the next day I was back at it, and I was ready to fight the fight, and I actually thought about the switch over from the Carter to the Reagan administration. And at the end of the Reagan administration, remember in 1986 what happened? IRCA. Who knew that IRCA was going to occur, that legalization would occur on his watch of all peoples? And it was no better time then. It took us all by surprise that happened. So I mean, I have to believe, and it may just be that I studied to be a Catholic priest for 8 years, I believe that anybody can be saved, which is useful if you're practicing law in Texas. I'm just saying. I genuinely believe that we're on the right side of history, and that doesn't remove us from the need to keep moving forward and to provide the legal argumentation and to throw the sand in the gear when it's necessary and so forth. If MALDEF didn't exist, someone would have to invent this today. And here we are 50 years later, looking back, assessing victories and losses, mostly victories that have moved this country forward. That's my take on it.
So let me just remind those in the audience here, if you have questions, please write them down on an index card. We're going to get to those in a minute. But Philma, let me ask you, has the nation learned the lesson of Plyler if we have conversations today about immigration enforcement in sensitive locations, whether that notion that you stay away from certain areas is going to survive under this administration? Have we learned the lesson of Plyler?
I'm not placing any bets on that one. You know, it was interesting to me to hear Michael talk about the potentially far-reaching impacts of having, if we had lost Plyler. And I never thought about that, because it didn't matter, because there was always something else to do. and we were going to find a way to do it. So my approach has always been very different. This could be why I always resisted efforts to go teach in law schools, Michael, because I just want to be out there doing what could be done, right? Doing what could be done that will shift. There are ebbs and flows, and that's just how it is. And I read this book years ago called The Leopard. And in this story, there's this Sicilian count who's, you know, the old guard, and he is talking to people who are upset that things are changing. And he says, well, you know, things will have to change in order that they may remain the same. And in a way, that's true. I look at our history, our civil rights history. I told you, thinking about the 30s repatriation, the 54 Operation Wetback. I saw IRCA in a different light from the way you did. I thought employer sanctions were wrong. So things change, they do. And yes, they remain to some extent the same, but not quite the same. So that we'll make progress, and then sometimes we won't, it'll go back. But we have to keep working if we expect to see the next spurt of progress. And one of the lessons that I learned, Tom, when I was a young lawyer just out of law school at the NAACP Legal Defense Fund, I learned that we could win a case, but people would still not gain rights. And you talked about this, Michael. And when you see it and you're a part of it, you feel truly powerless and ineffective. And I was very disillusioned, frankly, after only 3 years there. So I did other work, and I went to work at a Wall Street law firm and worked on the Pentagon Papers case there with Floyd Abrams, and that's when I went on the MALDEF board. That would have been 1970. And Mario Bledo, my predecessor, decided to leave, and I was whining that, you know, these people applying for the job couldn't do it, and of course I could do a good job. But the problem is I didn't think I'd get elected by the MALDEF board because I was one of the first 2 women on the board, and I had not been exactly nice and quiet, right? So I applied for it, and one of the things that I kept in my head was that whatever happened, I would not be disillusioned. I would just, if it just meant banging your head against the wall to try to make a modicum of change for some people, that is what I was going to do. And that is what I thought MALDEF had to do. So I think that enabled me to deal with different administrations, and certainly the Reagan election. And I know you, and I know that you have a similar temperament, shall we say, and that MALDEF will persevere, because that's what MALDEF does.
And I will just hasten to add, in regard to your story, that MALDEF is very proud today to have been led through 29 of its 49 years by women presidents and general counsel, starting with Vilma as the first. But Peter, you were retired, but sort of got drawn out of retirement by changed circumstances. As you are back in the fray because of those changed circumstances, has the nation learned the lesson of Plyler, or what more do we need to do to teach the lesson?
You know, the nation hasn't learned the lesson of treating people well. Has it learned the lesson of Plyler? Will there be challenges to Plyler? Sure, there'll be challenges to Plyler. I guess I'm of the same school as Vilma, that sort of says you keep plugging away, and in general we move forward. We may inch forward, and anyone who thinks you're going to have a panacea through litigation or through anything else is crazy. Although that's what we that's what we thought. That's what we thought. Actually, I was telling Michael that I did a little memoir when I started retiring, and I started out saying we thought desegregation was a panacea.
Yeah, that's right.
We did.
That's
we
right.
thought that if you could put kids together, black and white, Latino kids together, that somehow all the problems of race and economic discrimination would disappear. And of course it hasn't. We actually haven't put people together, even though we had all the law on our side. No, I mean, I am cautiously optimistic that the schools will remain, and that Plyler did help that along as sanctuaries that will remain. But clearly, the history of this country is of cycles of discrimination. If you study, you go back to the 1880s and come forward. You know, I used to think it was because of economic downturns that people would beat up on immigrants. It isn't always economic downturns. It just, God knows what it is that leads to these swings. Economic downturns clearly are a major flux, or at least economic downturns to certain groups. Vilma was talking about if you leave some groups out, if everybody isn't sort of elevated, you're going to have some dissidents, and those are the sorts of people who elected our current president and have caused the problem now. You've got to try as best you can. You can't solve all the problems, and there's some people who you just have to write off. But clearly, there's always going to be that cycle of discrimination against immigrants. It's not going to. It's going to end. It's never going to end in my grandchild's days. But I do have cautious optimism that the schools will be protected.
I want to make a comment about that too, which is this. I don't know, of course, what the future holds, but what I do strongly believe is that immigration has been this country's greatest strength, period. We don't always recognize it. I mean, look at this Muslim travel ban that we're dealing with now, the way the president spoke about Mexicans during the election, and women for that matter. But I think the demographic shifts in our country have taken place. It is done. So the only question is how we manage this demographic reality. I think that is the key. And for me, the key is to provide a sense of ownership to everybody. I read 2 books this past year that were very interesting. One was Hillbilly Elegy, which talked about the whites feeling very left out of the system, and I understand that. The other one was Dark Money, the influence of money in elections. And those are also realities, and those are all realities that all of us need to be aware of and try to bring people together. And as I say, the way, for me, the answer has always been giving people a sense of ownership in the enterprise being our country, and sense of ownership meaning you better participate.
Mm-hmm.
Thank you. So we have a couple of questions from the audience, and the first I want to direct to you, Michael, first, which is, we've talked primarily about Plyler versus Doe and the case that emanated from the Tyler School District. But there was another case later filed that ended up consolidated before the U.S. Supreme Court. And so the first question is about the Houston trial, and asking if you can talk about the Houston trial and whether there was any DOJ involvement in that other case.
Well, it was interesting because in preparation for writing my book on the case, I looked at the record. All the MALDEF archives are at Stanford, and I found these glorious nuggets here and there, many of them including signed by Peter and Vilma. And And I recognized some of the people there. Some had to do with the Hispanic Higher Education Coalition, which I chaired in D.C. when I was a lawyer there and a student. And there's this one interesting exchange with Peter and one of the lawyers who'd been a classmate of mine at Georgetown, who came here and, as a young lawyer, helped litigate this case, which was brought by the Houston School District, which was the state's largest. It's one thing to have Tyler, which is about 15,000 students maybe at the time.
Very small.
Even smaller than that. And it's another, at the time, Houston was over 220,000 students, the fourth largest in the country. As it happens, the woman who became my wife was on the school board just after, and she was an assistant superintendent at the time, so I began to see some of the inside story of this as well. And they brought suit, and these were consolidated. So you have one federal case with a small district, and the lawyers here trying to sort of piggyback onto our case. And Peter says, this is so great, he says, we have the facts on our side, and we're going to eventually take this beyond Tyler, but we have the advantage of having not so good counsel on the other side, and that won't be the case in Houston, because they had better lawyers here. And I think that was true. So he just bided his time, kept to his knitting. The school district here, went about, the litigation goes on. The cases are consolidated, but not until Judge Woodrow Seals, and Laura, I know you were in the courtroom at the time, a colleague of mine who was a law student at the time, and he says, has anything of any importance or significance ever been written in Spanish? And there's this audible gasp reported by the reporters the next day, and he has to back down and apologize and so forth. Well, so he was digging it out of his own self-made hole at the time and ruled, and then the cases were consolidated, and there was this back and forth of civil procedure. I call it in my book the dueling Peters, because Peter Shea on the other side, but it was our case. It could have gone the other way, and this happened to us with MALDEF since that time, where we sort of lost control of a case due to assignment, including one sort of typographical error kind of thing in an important Arizona case. So again, luck befits us. We win the case here. They're consolidated. They split the time, as Peter says. He says very modestly, characteristically modestly, he's batting cleanup. We just say the best hitter on the team always bats cleanup.
Right.
and so it was an important case. It finally hit the papers. The Texas. I'm sure, Peter, you felt like you were in the cauldron of newspaper media coverage, but if you go back and look at it, there wasn't all that much.
Yeah, sure.
Yeah.
It hits Houston big time every day, et cetera. This is, of course, before social media, but at the time, Houston actually had two papers, and they were always having stories back and forth with each other. So it was an important case. We were lucky it went the same way, with pretty good lawyering on the part of the folks here. A different fact pattern, because Houston was if you think Tyler's a big destination because of roses, Houston is an even bigger destination because of everything. And so the demography was different, the political dynamics were different, the lawyering was better. On the other side, Peter, as you witnessed it, you clearly saw that it was better lawyered, better argued in many instances, deeper expertise for the kind of fact witnesses that they were bringing forth, et cetera.
So, Peter, do you want to talk a bit about the later filed case and consolidated with the one that you started in Tyler?
Well, I mean, last night I sort of explained to people that one reason why this all happened was that I think early on I mentioned that I'd gotten a call on just before Labor Day, and there was a bunch of kids out of school and a bunch of parents who were willing to stand up, and I just didn't want to. I wanted to get them in school. If they were willing to stand up, I wanted to get them in school. I didn't want to get tangled up in statewide class action issues. And we knew this was going to go at least to the Fifth Circuit, if not the Supreme Court. And so I knew we were going to get a statewide ruling. But clearly the state of Texas is a lot bigger than Tyler is. And that then, of course, once we won, that led to this second suit down here, and that went on, and we had correspondence back and forth. In the Supreme Court, we consolidated, and we actually had, very compatibly, Peter Shea, who ran the case down here and argued it in the Supreme Court, was more of an immigration expert, and I had more of an education expertise, so that sort of worked out. There was one sort of last night sort of threatened to tell a story about and this sort of Plyler goes back to Hernandez versus Texas, which is probably the other major Chicano case in Texas and maybe in the country. There was a time when I'd argued in the Fifth Circuit, but there hadn't been a ruling, and the Houston case went forward, and there was a victory in Houston, and the Fifth Circuit still hadn't ruled. And the state went around to seek a stay of the Houston case. And you go to individual justices to get a stay. And I can't remember if it was I believe it was Justice Powell, but some justice said, I'm not going to grant a broad scale stay, but if an individual school district can make an application to their local district court judge that they are severely disadvantaged, they should be able to get out pending the appeals on all of this. So remember, I'd argued in the Fifth Circuit. They had just won here. We were waiting the Fifth Circuit ruling, and during this, Brownsville decided that they would apply to get out from underneath the in re alien children case. Turned out that for reasons that I won't get into, I was enlisted, even though this was an in re alien children's case. I was asked to try the case down in Brownsville, to go down to Brownsville to appear before the judge, along with Linda Llanes. So we got down in the courthouse on one morning to try to show that Brownsville, in fact, was not justified in getting a stay of in re alien children. And while I was sitting there waiting for the judge to come out, I got a note from a federal judge by the name of Jimmy DeAnda, who had been on the board of MALDEF, who I knew, saying he had just been appointed to the bench, but he had chambers in the courthouse in Brownsville, and he said, when you're through, come on up and say hello. So that's great. I stored that in my pocket. I was preoccupied with the hearing I was about ready to engage in. The judge came out, said there's not going to be a hearing today. The Fifth Circuit just ruled, and so there's no necessity for a hearing. You guys win because the Fifth Circuit had ruled, and then so I went up to Judge DeAnda's office, and he was there with Reynaldo Garza, who was the chief judge of the Fifth Circuit, and Jimmy DeAnda had done the Hernandez versus Texas case, the leading case at the time. And so the three of us sort of congratulated ourselves on the victory. They congratulated me, and it was sort of just a really poignant moment to be with these guys who had this history of defense of Chicanos in Texas, to be with them at the time that we had just heard that we had won the statewide ruling in Texas.
First two federal Mexican-American judges ever.
Right.
A terrific
Donda was the last one. He was in Houston, haven't had one since.
Right.
What a terrific story. It was an extraordinary victory, and Plyler versus Doe certainly belongs up there with Hernandez versus Texas as true civil rights victories of tremendous import. I want to thank the panel, Professor Michael Olivas, Vilma Martinez, and Peter Roos, for being with us here today. The second and last question from the audience is one that I'm going to address as we close this important commemorative program. I began by recognizing that it needed to be a living commemoration because there are ongoing threats to the principles, legal and practical, established in Plyler versus Doe. The question is, what are the most important things to watch for coming from Donald Trump's Justice and Education departments in the near term? And I will conclude with an answer to that from my perspective and the perspective of MALDEF. First of all, answering the question in all of its issues would take a whole nother panel, and certainly something worthy of having that kind of attention. But in the area of education, first and foremost, the Obama administration, with the participation of a former MALDEF attorney, issued Plyler guidance during the course of its second term. And there is a concern of whether the Education and Justice Department, which jointly issued that guidance, will seek somehow to rescind the guidance. If that occurs, it will be a warning sign of how involved or interested in supporting or undermining Plyler these two departments might be. I think in the realm of education, the other issue of concern with this administration is as it promotes more and more public education outside of public school systems, whether that's charter schools or through vouchers, there are serious questions about whether the principle of Plyler versus Doe will be followed and applied in all of those alternative settings. Now, there are reasons of concern to many in education and civil rights to oppose the whole notion of privatization. But if there is further movement to move children to these alternative public school settings, I think there are issues to be monitored and issues to be advocated and issues perhaps to defend Plyler and its application in those alternative settings. Not all of our states in their charter school laws ensure that charter schools have in their policies, in their charters, a guarantee of admission to all students regardless of their immigration status. Those are just two of the more direct possibilities of threat to Plyler versus Doe. But Plyler stands for so much more than simply the right of access to public education. As indicated, it was an indirect attempt to prevent kids from attending school, and we have many warning signs and challenges to watch for in that regard, whether it's immigration enforcement that's undertaken near schools or in school transit corridors, whether it is immigration enforcement that threatens parents of undocumented children and their citizen siblings who then face real education obstacles in public school, because going to school with a overshadowing fear of what may happen to your parents while you're in school definitely has an educational impact. So much of what Plyler established now 35 years ago is under threat, and something that it is important to commemorate, remember, and ensure the continued application of not just the outcome, but the principles of Plyler. And that is why MALDEF celebrates this case, not just as a singular victory of the organization in its 49-year history, but because of its continued and necessary vitality in 2017. So thank you all for being with us today, or here in person or by live stream, for this important living commemoration of the principles of Plyler versus Doe and a reminder of the need to continue to vindicate that important case. Thank you very much.
Thank you, folks.